治政府的治国方略呢，在制度设计的逻辑上是清晰而连贯的。通过刚才整个时间进程过程的梳理呢，我们可以看出它逻辑上的贯通性。另外，从具体内容的表述上，依法治国的宪法性的刚性条款，在17年的制度实践层面，已经细化为依法行政所着力的合法行政、合理行政、程序正当、诚实守信、高效便民、权责统一的具体规范。它已经不再是仅仅是一个抽象的规范，而是化解为一种在基层政府能够具体推进实施的具体的执法规范。那么从制度实践的层面上看，中央政府的宏观统一政策在基层政府得到回应，这是必然的。那么从基层政府工作的细节入手，去分析其政策的基本定位，其措施的具体落实以及执法状况的具体分析，就可以为我们提供一种政府法治微观透视的真实样本。这也正是我和我的团队呢，选择以城市执法状况作为调研分析对象的一个初衷。我选择呢是中国的 A 城市。那么下面介绍一下有关 A 市城市管理执法的一个基本状况。那么从城市管理执法的它的基本逻辑上，我们可以表述为，它是在寻求着一种有效的行政执法模式，形成一种行政执法的合力，来化解在转型过程之中、城镇化发展过程之中所可能出现的各种城市病，从而来实现建设和谐宜居、富有活力、各具特色的现代化城市。正是基于这样的一个基本的逻辑设计，在 A 城市有关它的行政执法本身，我把它梳理为一个非常有效的一个执法模式，称之为4公开1监督。4公开1监督，这个4公开1监督本身所强调的是公开城市管理责任部门，这实际上是一个部门清单。公开责任部门的执法责任和查处标准，这实际上是一个权力清单的公开。第三是公开责任部门的城市管理网格化及其责任人，这个为对最后的问责机制的构建呢提供了非常有效的保障。最后是公开责任部门越检查、越曝光、越排名的城市管理执法数据。4公开的基础如何保障它效果的实现？那么另外呢就是1监督，这个监督就是在城市管理执法协调部门统领下，由监察部门介入，对于所属执法部门的执法状况进行有效的监督。那么4公开1监督从它的逻辑结构上，为我们同仁呈现出这样的一个基本的状况。刚才所说的4个方面的公开和1个方面的监督。那么从这个4公开1监督它整个工作实施情况来看，我理解它做到了以下几个方面的有效的工作，从而凸显了这项工作本身的这个特色，也为它效果的呈现呢提供了非常有效的保障。第一个方面呢，4公开1监督本身是对现有制度规范的系统梳理，因为城市管理所涉及到的领域，目前我们梳理了 A 城市它所涉及的21个管理事项。那么在这些事项中，涵盖了289种法律、法规、地方性法规以及政府部门规章的作为有效的执法依据。这可以说，在整个的4公开1监督的执法模式实施过程之中，这个执法依据是充分的，依据保证了责任主体、责任部门、执法标准、执法依据，从而保证了我们行政职权的行使本身的 有法可依。那么第二个方面呢，它的特色就是司公开一监督本身对于纵向层级和横向部门之间的职权关系进行了一次全方位的科学理定。因为城市管理执法所涉及到的部门是多层级的、多方面的，而在整个的 A 城市城市管理执法推进过程之中，明确了管理的领域，明确了在每一个领域所涉及到的行业的主责单位、执法主体和其他责任部门，从而形成了横向、纵向、多方位的一个执法实施的这样一个部门体系，所以对它纵向、横向的职权关系的梳理起到了很好的作用。那么第三呢，是形成了一种整合城市管理责任主体体系的这样一个创新的模式。这个模式呢，我们称之为网格化的城市管理服务体系。那么这种网格化的服务体系呢，用这样一个图示呢来给予呈现，所涉及到的就是政府、属地政府，就是执法本身所涉及到的属地政府本身如何作为管理主体，那么行业权属部门如何作为管理主责部门，那么执法部门在配合方面的这样一个定位要求，以及综合协调部门的指导评价和最后的监管部门的综合监督。在这样一个网格化的体系过程之中，城市管理执法本身它的状况尽览其中，从而呢为发现在城市管理执法过程之中的各种问题提供了一个非常有效的组织化层面的这样的一个管理体系。同时呢，建立这种网格化的这种服务体系本身所强调的是对规范城市管理和执法呢，对于它的手段、目的都给予了进一步的强化。这种强化呢，我们把它理解为，第一呢，它是统一了整个城市管理执法的这样一个标准，统一了城管执法的一个裁量基准，同时呢，强调用程序法的刚性要求来规范执法行为，同时用细化的自由裁量权来压缩实体法的弹性空间，从而立足于4个方面来实现执法理念、执法手段和执法方式的进一步提升。同时呢，这个司公开一监督的这种执法模式呢，对于现代城市管理也提供了一种非常有效的畅通城市管理信息渠道的这样一种尝试。这种信息渠道，一个是在管理层面上的统一数据信息的畅通，另外一个就是在民众层面的对于各类信息的这样的一种有效的浏览、监督。这样的一种畅通的信息沟通模式、工作机制的构建呢，在整个的我们国家 A 城市城市管理执法过程之中所发挥的作用是非常突出的。最后一个特色呢，我们称之为它是城市管理自律与他律相结合的手段。说自律就在于它这里边强化的是日常性的行政监督，在城市管理所涉及到的重点的这些领域呢，城市管理执法部门及时的数据上报、及时的工作梳理、及时的执法状况的这样的一种微观调控呢，是非常有效及时的。同时呢，我们说他律，就是不光是执法机关的自律，而且是他律的这样的一个形成，就在于它在接受着来自于统一协调部门的有效监管，同时也受到了来自于社会各方面的有效监督。那么从整个这种 A 城市城市管理执法状况的这种实施模式，从它的效果上来看，我们总体来评价，可以这样来说， 就是说，这种管理模式本身在它市属所属地方政府、基层政府、各执法部门这个领域之内得到了积极的响应和支持。同时，在涉及到城市管理的重点领域，尤其是城市环境、污染等方面，它的秩序得到了有效的改善。百姓对于城市管理执法的满意度也在不断的提升。那么这种效果本身，从我的研究报告提供于同仁的有几个方面的呈现。一个是这种积极的响应的执法数据的上报，为提供整个城市管理执法监管呢提供的这种有效的一个参考依据来看，是不断提升的。另外，从纵向、横向各部门之间的协调角度来看，这种执法模式的有效实施也是得到充分认可的。随后呢，我们所涉及到的城市管理秩序的重点领域的持续改善是得到了有效的保障。同时呢，我们还有一组数据，这是由第三方对于 A 城市城市管理执法状况进行的有效评价。在2013年，这个来自于百姓的执法的满意度是76.43%。那么在2014年，这个满意度得到了一个基本的稳定，稳中有升，就是76.71%。在这样的一种基本均衡的执法状况下，我们所能感受到的，就是百姓本身对于 A 城市城市管理执法综合状况的一个满意情况。同时，在70%左右的这样一个满意度的基础之上，也暴露出了我们在城管执法过程之中所存在的问题和它改进的空间。那么这种问题和改进的空间，在我的研究报告中最后集中在了这么几个方面。第一呢，就是城市管理的执法应该强调执法重心的下移，而不仅仅是在城市管理主管层面，而是在基层层面。第二呢，就是城管执法本身必须得到有效的监督，也就是说，任何一种公权力的行使，在涉及到百姓利益，哪怕是在谋福利的过程之中，那么公权力本身得到的有效的制约是必须给予保障的。第三，有关城市管理本身，它并非仅仅是城市管理某一个部门的问题，它实际上涉及到是整个城市管理运行过程之中的综合治理问题。而综合治理问题的关于这个问题的思考，在我的理解之中，不仅仅是中国政府法治面临的一个急需创新、急需总结的一个问题，在我的理解之中，在金砖5国我们共同的交流发展过程之中，对于每一个国家可能都会涉及到与综合治理有关联的一种新的秩序模式构建的一种选择。那么关于这一点呢，我非常渴望在会后呢，与我们的同仁有更深入的交流。我的报告完毕，谢谢大家。
I must say, when I went to China, I was indeed fascinated by the city and the urban development. It's indeed something to learn from and see. And in fact, we would love to enforce these kind of urban law enforcement designs and enforcement patterns as much as possible within our country also. There's something to learn. Thank you very much, Liu. I would now like to call Mr. Shyam Divan, who's the senior advocate here and the Vice President of Bar Association, who would be speaking on judicial activism and foreign direct investment in India. Shyam.
Thank you very much, Pinky, and good morning to everyone on the dais as well as in the audience. Great pleasure to be here. I thought that perhaps what I should do is just summarize the 4 points I want to make very quickly right at the beginning, and then leave it to each one of you to return to your electronic screens or to go out and enjoy the weather or whatever. So there are just 4 points. The first point is that India desperately requires foreign direct investment, and I'll briefly explain as to why and what the position is. The second point is that we in India start from a pretty low base in terms of ease of doing business. The third point I want to make is that there's been quite a bit of dramatic reform and activity which is ongoing to try and ensure that ease of business is greater. And the final point, which links up with the judicial activism part of my subject, is that in India, since almost the 1980s, certainly in the 1990s, we use courts and judges as a method of governance. So that's quite different, and it's quite unusual from many jurisdictions where courts and judges are regarded as dispute resolution machineries. But in India, now our constitutional courts are instruments of governance. So I'll deal with that towards the end. Now, on the FDI point, we were around, the big need for FDI in India is, first and foremost, we require a huge amount of capital for the new thrust of government, which is to manufacture in India. And Indian industry and Indian capitalists, etc., are pretty stretched. So we were ranking around, in 2013, about the 15th sort of destination in terms of attractiveness, in terms of FDI inflows. But in 2015, it became the highest. It became #1 in terms of FDI inflows, largely because of the Make in India campaign of the Government of India. And in the first 6 months of 2015, the FDI inflow was to the tune of about $31 billion. So that's a lot of money. Now, the necessity for this is not just the fact that Indian capital is not available, but also India needs to create 13 million new jobs a year. So that's almost more than 1 million jobs a month. So that's an enormous challenge, a big asking rate, 1.25 billion population and growing. So that's the big necessity. Now the second point is with regard to the low base which we start from. And here I sort of draw on a book by an author, Mihir Sharma. And the title of his book is Restart, the Last Chance for India's Economy, or to start India's economy. And he writes about an act which we had called the Factories Act of 1948, which essentially governs manufacturing. And he analyzes the act and he finds that you require to maintain 28 registers under this act. And not only do you have to register and record 28 items, one of the items which he discovered you have to register and record, and with respect to which there's an inspector, is called the lime register. And the lime register records as to how often and how well you paint your factory or whitewash your factory. And that's why the element or the use of the word lime, whether you're using adequate lime on it. Now, fortunately for us, there has been a cleaning up of statutes and removal of dead wood in the last 3 or 4 years. And the result is that many of these statutes, such as the requirements for a lime register with an factory inspector coming to your office, has been eliminated. And the ease of doing business to that extent has improved. But India still ranks very, very low. And despite the improvement in 2015 by 12 spots, so we improved 12 spots in the global ease of doing business ranking, we still are at 130 in 2015. So the current aim is now to improve and to pierce that 100 barrier and to be within the best 100 destinations. And there's been dramatic improvements in 2 and 3 departments. The first has been, for example, just to mention one, is electricity. And one would think that perhaps the availability and generation of electricity has improved, which it has. And you now, for the last 2 years, have at least notionally surplus electricity generation capacity. But the real reason why India scaled up so well in terms of the provision for energy was that the states as well as the union government dramatically curtailed the power of electricity inspectors. So that's again an idea of the type of reform which is required and the type of reform which is coming in. So this is what is resulting in an improvement in terms of the India rank insofar as ease of doing business is concerned. The other point I would like to mention is there's been a huge a raft of reforms which have come in the form of new legislative initiatives to make it more attractive to do business. So one field insofar as the law is, or rather one major thrust in this law is concerned, is that we have new commercial courts which are mandated to dispose of commercial cases within a time-bound manner and where you will have specialist judges. Another is in respect of arbitration, where we have a new arbitration, a major amendment to the existing arbitration law to bring it up to global contemporary standards. A third area is a new bankruptcy code, a relatively new Companies Act, and I think perhaps the most significant in the recent legal reforms which have taken place is the introduction of a constitutional amendment, and which will be followed by statutes for something called the Goods and Services Tax. So this is a big bang reform. It's the type of reform which will dramatically alter and change the manner in which businesses pay their taxes. Otherwise, the traditional photograph of rural India is often you have situations where you have long lines and queues of trucks which are waiting to enter cities, which are waiting at state boundaries. And the reason for the queuing up and this lengthy delay is because they have to pay a border tax. All of that is apt to be or likely to be eliminated with the new Goods and Services Tax. This is, of course, going to be dramatic, but it's very complex because we are a federal structure. So we need to change the constitution, we need to change and repeal state laws, we need to introduce new federal legislation. So it requires a lot of compromise and give and take as between the states as well as the union government. But that's a hurdle which has been crossed, and I think there's going to be a huge dividend in terms of ease of doing business, which is there in the future. The next point I'd like to make, which is with respect to and probably the most interesting facet for at least those of you who are new to the Indian legal system, is governance through courts. And in this regard, I'd probably just hark back a few years as to what happened in terms of just constitutional developments. In the 1980s and in the 1990s, the Supreme Court rediscovered itself. The Supreme Court is the highest court that we have. It's a constitutional court. And they're very powerful in the sense that they have the power of judicial review, the judges and the personnel in the Supreme Court of India. They can strike down legislation which has been passed by a legislature if it contradicts any of the provisions of the Constitution. And the Indian Supreme Court has also reserved to itself a very rare power, which is the power to strike down even a constitutional amendment. So you can have Parliament introducing a constitutional amendment, you can have the state legislatures approving the constitutional amendment, but it must still pass a test, which is very, very rarely applied, but applied occasionally, where if you find that there is a basic feature of the Indian Constitution which is being taken away by the legislature, then the court will protect that basic feature and not allow the constitutional amendment through either. So while the Supreme Court was finding this new voice, it decided sometime in the 80s, very, very gradually, and then into the 90s, and then the first decade of the present century, to gain its own relevance and to connect directly with the people. And in order to do that, it started entertaining petitions which would improve the quality of governance. So the court found that there was a huge governance deficit in India, in terms initially in the sphere of human rights, but then in larger areas such as the environment, etc. And to give you just one example, it found that we had a very beneficial scheme for improving nutrition among school children, and it was a midday meal scheme by which students in schools were guaranteed a good meal, a healthy, wholesome meal in school. But there were huge gaps in terms of the efficacy and the efficiency with which this was being administered. So the court found that this was so crucial for future generations, for the well-being of the nation, to ensure that children attended school, that the Supreme Court of India virtually oversaw on almost a week-by-week basis the delivery of food and good wholesome meals through the judicial process. So that's why I use the expression that judges have become, in the Indian context, for the last more than 2 decades, instruments of governance, and they have assumed this role. Now, what's the impact this could have on foreign direct investment? Well, the impact sometimes could be an element of uncertainty. And we had an experience of that recently, where the Supreme Court of India, I mean, just to step back for a bit, New Delhi in 2014 was declared by some measures to be the most polluted or the grubbiest city in the world in terms of air quality. So it sort of had surpassed Beijing, and the judges in our courts gave some time to the administration to react and respond, but nothing was forthcoming. And then the courts felt that, look, this is bad enough that we are right up there on this list where we ought not to be. And if the government is not responding, we are going to take a huge and a strong initiative. So the court's initiative included, there was a huge number of measures, but one of those measures was that you could not register cars which had an engine capacity of over 2,000 cc in the entire national capital region, which is about 49,000 square kilometers in and around New Delhi city. So that had a crippling impact, as you can imagine, on motor car manufacturers, because very many of the large manufacturers who manufacture diesel vehicles were finding that they just couldn't sell these vehicles in a large part of India. Well, the good bit is that about 8 months down the line, the court realized that this was probably not quite the way to go, and therefore altered its own order and allowed registration to, upon payment of an extra charge of 1% of the price of the vehicle. So one way of looking at it is that this suddenly enhanced risk, this introduced judicial uncertainty, it introduced economic uncertainty. This was not a fair way of going about it, and this was not the traditional role of a court. But I think the way the court would look at it is a little different. The court would look at it and say that, look, we want to clean Delhi's air. We find that the governance factors, for example, in the previous presentation by Professor Liu Zejun, you heard about how many departments there are in every city in China to look after certain issues like waste management and disposal of, ensuring that you have sewerage and ensuring that you have proper administration. The Indian Supreme Court found that there was a gap in this as far as Delhi's air quality is concerned. They waited long enough and they said, we're going to try new initiatives, even if they are disruptive in the near term. But overall, I think the court was able to elevate the importance of environment. They were able to make citizens as well as government realize the importance of this. They introduced a prohibition, and then when they realized that maybe the time now has come to retreat